If you have an I-130 petition pending, or you're planning to sponsor a family member to come to the United States, what I'm about to tell you could completely change your timeline and your family's future. Starting February 2026, major changes are coming to I-130 processing priorities, and thousands of families could face unexpected delays that might keep them separated for months or even years longer than they anticipated. Do not click away because this information is absolutely critical for anyone navigating the family-based immigration system right now. Welcome to US Visa Info, your most trusted source for accurate, up-to-date information about United States immigration visas and pathways to reuniting families. I'm here to break down the complex world of US immigration law into clear, actionable information that you can use to make the best decisions for your family's future. If this is your first time watching, please subscribe and turn on notifications so you never miss critical updates that could impact your immigration journey. Today, we're What is Form I-130, covering breaking news about I-130 priority changes that will affect countless families starting in just a few weeks. And you need to understand exactly what this means for you. The I-130 petition, officially called the Petition for Alien Relative, is the foundation of family-based immigration to the United States. This is the form that U.S. citizens and lawful permanent residents file to sponsor their family members for immigration benefits, whether you're sponsoring a spouse, parent, child, or sibling. The I-130 is where your journey begins. Currently, hundreds of thousands of these petitions are filed every single year, and processing times have been a major concern for families desperate to be reunited. Let me give you some context about how the current system works before we dive into what's changing right now. USCIS, the United States Citizenship and Immigration Services, processes I-30 petitions based on several factors, including the type of relationship, the petitioner's status, and the service center handling the case. Processing times vary dramatically depending on these factors. Some immediate relative petitions filed by U.S. citizens can be processed in as little as 10 to 15 months, while preference category petitions can take much longer. USCIS confirms priority changes, and that's not even counting the Visa Bulletin wait times that come after approval. The immigration system divides family-based petitions into two major categories: immediate relatives and family preference categories. Immediate relatives include spouses of U.S. citizens, unmarried children under 21 of U.S. citizens, and parents of U.S. citizens who are at least 21 years old. These categories are considered immediate because there are no annual numerical limits on how many visas can be issued. Once the I-130 is approved and other requirements are met, the visa or adjustment of status can proceed without waiting for a priority date to become current. The family preference categories are different. These include F1 for unmarried sons and daughters of U.S. citizens, F2A for spouses and unmarried children under 21 of lawful permanent residents, F2B for unmarried sons and daughters 21 or older of lawful permanent residents, F3 for married sons and daughters of U.S. citizens, and F4 for siblings of U.S. citizens. These categories have annual numerical limits, which means even after your I-130 is approved, you may have to wait years or even decades in some cases for your priority date to become current before you can actually get your visa or green card. Now, let's talk about what's when the new rules start, Feb 2026, changing in February 2026, and why this matters so much. According to the latest announcements, USCIS is implementing a new priority system for processing I-130 petitions. This new system is designed to address the massive backlog that has built up over the years, but the way they're prioritizing cases could have significant impacts on when your petition gets processed. The changes are being implemented to supposedly improve efficiency and reduce overall processing times. But as with any major system change, there will be winners and losers. Under the new priority system, starting in February 2026, USCIS will be processing I-130 petitions based on a tiered priority structure. The highest priority will be given to certain immediate relative categories, specifically spouses of U.S. citizens and parents of U.S. citizens. These petitions will be expedited through a dedicated processing track with a goal of completing them within 6 to 9 months from the date of filing. This is actually good news for people in these categories because it's faster than many current processing times. The second tier of priority will include unmarried children under 21 of U.S. citizens and all F2A preference category petitions, which are spouses and children of green card holders. These cases will be processed with moderate priority, with estimated processing times of 12 to 18 months, again depending on current processing. Which family categories are affected times at specific service centers? This could be an improvement, or it could mean slightly longer waits for some applicants. Here's where families need to pay close attention and where the delays come in. The third tier, which will be processed with standard priority, includes F1, F2B, F3, and F4 preference categories. These are unmarried adult children of U.S. citizens, unmarried adult children of green card holders, married children of U.S. citizens, and siblings of U.S. citizens. Under the new system, these petitions could see processing times extend to 24 to 36 months or even longer. This is significantly longer than some service centers are currently taking to process these petitions, but there's another layer to this that makes the situation even more complex. The new system also introduces what they're calling administrative prioritization factors. This means that even within each tier, certain cases may be processed faster than others based on additional criteria. For example, petitions where the beneficiary is already in the United States in valid status may receive higher priority than those where the beneficiary is outside the country. Petitions with complete documentation and no requests for evidence may move faster than those that are missing information. Additionally, USCIS has indicated that they will prioritize cases where there are compelling humanitarian factors, such as serious medical conditions, the safety expected delays explained of children, or other urgent circumstances. While this sounds reasonable, the lack of clear guidelines about what qualifies as compelling means that families won't necessarily know where their case falls in the priority system, creating uncertainty and anxiety. Let me explain why these changes could be particularly problematic for certain families. Imagine you're a U.S. citizen who filed an I-130 for your sibling 2 years ago. Under the current system, your petition might be nearing approval, but if your case hasn't been decided by February 2026, it could be moved to the lowest priority tier, potentially adding years to your processing time. Your sibling who has been patiently waiting could face an indefinite extension of time before even getting the I-130 approval, after which they still have to wait for their priority date in the Visa Bulletin, or consider a green card holder who filed for their adult unmarried son or daughter. These F2B cases already face long Visa Bulletin wait times, sometimes over 5 to 7 years, depending on the country of origin. If the I-130 approval itself now takes 3 years instead of the current 12 to 18 months at some service centers, you're adding multiple years to an already lengthy process. For families from countries with high demand, like Mexico, Philippines, India, or China, this could mean waiting 15 years or more total before their family member can join them in the United States. There's also green card holders versus U.S. citizens' concern about how these changes will affect families who are in the middle of their immigration journey. USCIS has stated that petitions filed before February 2026 will be transitioned into the new priority system based on their category, not based on when they were filed. This means that being in line first doesn't necessarily mean you'll be processed first anymore. A petition filed in 2024 for a sibling could be processed after a petition filed in 2027 for a spouse, completely upending the traditional first in first out approach that many people have come to expect. Another significant concern is the impact on derivative beneficiaries. When you file an I-130 for your spouse, their children under 21 can often be included as derivative beneficiaries. If processing delays cause a child to age out, turning 21 before the petition is approved, they may lose their derivative status and require a separate petition, creating additional delays and complications. The Child Status Protection Act provides some relief in certain circumstances, but aging out remains a critical issue for many families. Now let's talk about what you can do to protect your family and navigate these changes. First and foremost, if you haven't filed your I-130 yet and you're eligible to do so, seriously consider filing as soon as possible. Petitions submitted before what you should do right now. February 2026 will be grandfathered into the system, and while they'll be assigned to priority tiers, getting your petition on file earlier rather than later is crucial. Every month you wait is potentially another month added to your processing time under the new system. Second, make absolutely sure your petition is complete and accurate when you file it. Under the new priority system, incomplete petitions or those that generate requests for evidence will likely be deprioritized. This means working with an experienced immigration attorney or being extremely thorough in preparing your petition yourself. Include all required documentation, provide clear and consistent information, and make sure your evidence of relationship is strong and well organized. Third, if your petition is already pending, monitor it closely. You can check processing times on the USCIS website, and you can also create an online account to track your case status. If your case is taking longer than the posted processing times, you may be able to file an inquiry or even consider a mandamus lawsuit. In extreme cases, though, you should consult with an attorney before taking such steps. Fourth, stay informed about Visa Bulletin movements if you're in a preference category. Even if your I-130 is approved quickly, you'll still need to wait for your priority date to become final advice and key takeaways current. The Visa Bulletin is published monthly by the Department of State and shows which priority dates are currently being processed. Understanding how to read the Visa Bulletin and what it means for your case is essential. Fifth, consider whether you have any other immigration options. For example, if you're waiting for an F2B petition as the child of a green card holder, but your parent naturalizes and becomes a U.S. citizen, your category could change to F1, which typically has shorter wait times. Or if you're eligible for employment-based immigration, that might provide an alternative or faster path. Every family situation is unique, so exploring all options with an immigration professional is worthwhile. It's also important to understand the political and practical context of these changes. USCIS has been under enormous pressure to reduce backlogs and improve processing times. The agency has faced criticism from Congress, immigrant advocacy groups, and the public for lengthy delays that keep families separated for years. These priority changes are meant to address those concerns by focusing resources on the cases that should theoretically move fastest. However, critics of the new system argue that it creates a two-tiered immigration system where some families are valued more than others. They point out that siblings and adult children are still close family members who deserve to be reunited with their U.S. citizen or permanent resident relatives. By deprioritizing these categories, the government is essentially saying that these relationships matter less, which many find troubling from a family values perspective. There's also concern about the lack of transparency in how the new priority system will actually work in practice. USCIS has provided general guidelines, but many details remain unclear. How exactly will humanitarian factors be evaluated? What happens if you're on the borderline between two priority tiers? How will the agency handle cases that have been pending for many years already? These questions create uncertainty for families who are trying to plan their futures. From a practical standpoint, families should also be aware that these changes to I-130 processing are happening alongside other shifts in U.S. immigration policy. Visa Bulletin retrogression, changes to public charge rules, updates to visa interview procedures, and other policy modifications all interact with each other to create a complex landscape. What seems like a simple family-based immigration case can quickly become complicated when multiple policy changes affect different stages of the process. For families who are facing these potential delays, the emotional and practical impacts can be devastating. We're talking about spouses separated from each other, children growing up without a parent, elderly parents unable to be with their adult children in their final years, and siblings who may never have the chance to live near each other. These aren't just bureaucratic delays. They're real consequences that affect real people's lives in profound ways. If you're feeling overwhelmed by all of this information, that's completely understandable. The U.S. immigration system is incredibly complex, and changes like these add another layer of complication. This is exactly why channels like U.S. Visa Info exist, to help you make sense of these changes and understand how they affect you specifically. Immigration law is not one size fits all, and what applies to one family may not apply to another. I want to emphasize that while this news about priority changes is concerning, it's not a reason to give up hope. Thousands of families successfully navigate the immigration system every year, even with its challenges. The key is staying informed, being proactive, preparing your case thoroughly, and seeking help when you need it. Whether that's through immigration attorneys, nonprofit organizations that provide immigration services, or educational resources like this channel, support is available. Also, remember that immigration policies can change sometimes quickly. What's announced today might be modified tomorrow based on public feedback, court challenges, or changes in administration. Staying engaged with immigration news and understanding your rights is crucial. If you believe these policy changes will harm your family unfairly, consider reaching out to your congressional representatives, supporting immigrant advocacy organizations, or participating in public comment periods when they're available. Thank you so much for watching US Visa Info today. I hope this breakdown of the I-130 priority changes has given you a clear understanding of what's happening, why it matters, and what you can do about it. If you found this information valuable, please give this video a thumbs up and share it with other families who are going through the immigration process. Knowledge is power, and the more informed our community is, the better equipped we all are to face these challenges together. Make sure you're subscribed to US Visa Info so you don't miss future updates about immigration policy changes, processing times, and strategies for reuniting your family. Drop a comment below if you have questions or if you want me to cover specific topics in future videos. Remember, your dreams of family reunification are valid and worth fighting for, and I'm here to provide you with the information you need to make those dreams a reality. I'll see you in the next video. Stay strong and stay informed.